Okay, thank you very much for the introduction. I have slightly modified the title of my presentation because what I will present are some fragments of a bigger picture yet to come, or pieces of a puzzle, if you will, where still many pieces are missing. I will build on what Søren has presented, and I will talk about certain ways in which animals can be represented in legal proceedings, and I will take German law as a starting point and then draw a comparison to the mechanisms enacted in Austria. My presentation consists of 4 parts. First, I will address the role of animal protection commissioners in Germany. Then I will turn to the Austrian version, which is called ombudspersons, as we've already heard. Third, I will revert to Germany and deal with the so-called Tierschutzverbandsklage, a special procedural avenue for NGOs to represent animals. And lastly, I will distill some recommendations from these findings. So, animal protection commissioners in Germany. Currently, 11 states of Germany have a state animal protection commissioner, and since last year there is also one at the federal level. Between these 11 states and the federal level, there are considerable differences in how the appointed person views her role and consequently in how she exercises her tasks. Let's have a closer look at the framework in which the commissioners operate. What other players are there when it comes to the enforcement of animal protection law in Germany, and how do they interact with each other? The commissioner is, I hope you can read it, the commissioner is appointed by the government, either the state government of the respective state or the federal government. And he or she is appointed either as a civil servant or as an employee of the state. Only in 2 states they are unpaid volunteers. Formally, the commissioner is part of the administrative structure, but outside the usual hierarchy, as opposed to the local administrative authorities in the form of agencies or offices, mainly the veterinary offices at the district level, which are under the supervision of the government. This supervision of the agencies and offices is organized in a strictly hierarchical manner, which means that the government can make orders vis-à-vis the agencies in particular cases or in a general manner, and in each office, superior officers can make orders towards their subordinates. The commissioner stands outside this hierarchy and has the opportunity to advise the veterinary offices and agencies, as well as the government, also in the legislative process, for example. She can provide her expert opinion and legal evaluation of particular cases, general matters, or propose model solutions. To be able to do so, she has to rely on the information provided by the competent authorities. This is why it is generally assumed that these authorities are obliged to provide the necessary information to the commissioner, at least upon her request. Unlike the animal protection commissioners, the veterinary officers can make orders vis-à-vis private individuals to enforce their compliance with animal protection laws. For example, in order to provide adequate food to an animal, or to refrain from certain harmful practices. In reaction to such an order, the concerned offender or addressee of the order may appeal to the administrative courts and challenge the order, made by the veterinary office, whereupon the court may annul the order or require the office to make a different order. So, what does the commissioner do in this interaction? The commissioner can neither exercise official powers or even formally request a particular order, nor can she challenge the actions or inaction of a veterinary office or agency before court. She only has this advisory or admonishing functions towards the administrative bodies. In addition to these two functions, the commissioners also fulfill a coordinating and educative function. They receive suggestions and information from NGOs or interested citizens and educate the public on animal-related topics. So all these functions of the commissioner that I derived only make sense if the commissioner has a status independent from governmental or political influence. It is a pivotal feature of the position to be able to criticize the government and the administrative bodies. Such criticism, however, is only possible if the commissioner does not have to fear negative consequences. Otherwise, there would be no difference to internal discussions within an office between officials within the administration. Towards the public, independence from the government also and from politics also lends credibility and authority to the position, which the commissioner cannot derive from coercive powers, contrary to the regular administrative bodies. On the other hand, due to the lack of coercive powers, no accountability to the government, the parliament, or the public is democratically required, or at least to a lesser extent. So in short, the deal for the commissioners is you don't have any official powers, but in turn you can act independently from human interests and only in the interests of animals. At least that would be the idea in theory. However, the problem is that this reasoning is lacking an explicit statutory basis. In most states, there are no statutes at all governing the position of animal protection commissioners. Only 2 states have enacted provisions dealing with the position, but they are rather scant and do not address the issue of independence. The requirement of independence and the functions of animal protection commissioners can therefore only be derived in 3 ways: by applying provisions concerning similar commissioners. There are other commissioners in Germany, for example, anti-discrimination commissioners or police commissioners, not police officers, but responsible for supervising the police and others. And you could apply these provisions by way of analogy. Second, by interpreting the employment contracts of the commissioners, or third, by referring to past practices, how the position has been dealt with in the past. As you can imagine, not every politician likes the idea of an independent critic in the field of animal protection. That's why currently there are attempts in 4, soon maybe 5 German states to silence some of the most active and critical commissioners through political pressures and through the issue of supervisory orders or by drastically cutting their budget. In light of this, it is at least somewhat helpful that at the federal level, the draft of the new Animal Protection Act, which is currently under reform in Germany, devotes a new provision to the Federal Animal Protection Commissioner, explicitly mentioning her independent expertise, so her independent status. If we now secondly move to Austria, we can immediately spot some differences. The representatives of animal interests are now called ombudspersons and not commissioners. And there is an ombudsperson in every one of the 9 states of Austria, but not on the federal level. The basic structure of the players involved is the same. The appointment of the ombudspersons by the state government is provided for in the Federal Animal Protection Act, which also lays down the function and the powers of the position. Most importantly, section 41, subsection 9 of this act says that the ombudsperson is not subject to any supervisory orders from the government. In the administrative proceedings, the ombudsperson is not only an external source of advice, as in Germany, but a party to the proceedings. As such, she has the right to access all the information gathered in the records and can file formal petitions to the veterinary office or agency. Moreover, section 41 of the Animal Protection Act explicitly stipulates that the ombudsperson may appeal a decision to the administrative courts and challenge its compliance with the interests of animal protection. That's the wording of the statute. So this is a much stronger procedural position than the one of the German commissioners. At a closer look, however, there are some drawbacks. First of all, some important areas are excluded from the scope of judicial review initiated by the ombudspersons, like animal experimentation, animal transports, hunting and fishing. Furthermore, in criminal proceedings, the ombudsperson only has a passive role, not going beyond access to information. And finally, the effectiveness of her procedural rights is weakened due to insufficient resources, especially the lack of her own staff and legal expertise. Nevertheless, the Austrian ombudspersons participate in dozens of court proceedings each year. If we now turn back to Germany, it gets fragmentary again. In 8 states, representative actions, which can be launched by NGOs, are in place. There is some overlap between states with an animal protection commissioner and states with representative actions, but a few states only have one or the other. So how do these representative actions work? Each of the 8 states has its own act regulating the procedure, but the basic structure is always the same, and in fact it's modeled after the rules which implement the Aarhus Convention. So there we have a small Aarhus Convention for animals on the national or even regional level. Animal interests are now represented by an NGO, which has committed itself to the protection of animals according to its statutes. The NGO has to become accredited by the state government through a more or less intricate accreditation process. Once accredited, it can participate in administrative proceedings concerning animal protection issues. To this end, the NGO is granted the right to request information from the authorities. And this is already one of the main hurdles for NGOs, since the relevant provisions are quite complex, referring to other mechanisms such as freedom of information legislation, or requiring a 2-step procedure to obtain first an overview of ongoing proceedings and in a second step information from a particular file. Additionally, the authorities may refuse access to information due to privacy or secrecy interests of other persons involved. And as a further practical hurdle, some officials require representatives of the NGO to visit their office in person in a specific, narrow, and non-negotiable time window to inspect the requested files. Based on the information it eventually receives, the NGOs in most states have the opportunity to file an opinion in the administrative proceedings. This opinion is not binding, but it serves as a precursor to potential court proceedings later on. Once the veterinary authorities have reached a decision or refused to decide, an accredited NGO can challenge their action or inaction before the administrative courts. Such a petition is linked to the prior participation in the administrative proceedings, as the NGO can only bring forth arguments that it has already used in its opinion. Further restrictions concern the type of proceedings. For instance, only declaratory proceedings are available, or regarding the subject matter, for instance, animal experimentation is excluded or has higher requirements, and the standard of review, for instance, no constitutional law may be invoked in some states. However, the biggest hurdle for NGOs are the costs of the proceedings, or the cost risks, because hiring a lawyer is not prescribed, but it is practically inevitable, including 2 appeal stages, which may very well become necessary. The costs can amount to tens of thousands of euros, which are partly borne by the losing party, but not all of them. Lawyers' fees exceeding the statutory amounts have to be borne by the party who incurred them. So mainly due to these financial hurdles, but also in light of the other difficulties, not many court proceedings are conducted by NGOs in Germany in the field of animal protection law. So far, there have been around 20 to 30 proceedings over a time of around 10 years, or sometimes even a bit more, depending on the different states. In 20 to 30 in total in all states, most of which have not been successful. In one state, North Rhine-Westphalia, the representative actions have been abolished after several years. And at the moment, there are rumors that the state government of Berlin is also planning to repeal or at least weaken the regime of representative actions for animals. This is of particular concern because by far the most proceedings are conducted in Berlin, with 6 cases currently pending and another 2 underway. And most likely these cases will be lost if the law is amended before the final decisions of the courts. Yeah, these were the restrictions I already mentioned. So now what lessons can be learned from these different models in Germany and Austria for the representation of animals in legal proceedings? In relation to an offender who may defend his or her interests before court, the procedural equality of arms requires representative actions with a representative of animals who advocates purely for animal interests and not being pre-filtered by any weighing against human interests, as the other administrative authorities do it. Such unfiltered representation requires first motivation to do so and independence of the representing entity. The required motivation can be ensured through a selection process in which the motivation has to be demonstrated. As an alternative to one single representative, it is also possible to have a representative body or a committee, and there are also animal protection committees in Germany, which I didn't mention before. Also in Austria, there are these committees, but the problem with committees is that their decision making is quite cumbersome, and they do not convey the impression of one strong voice which can act quickly. The required independence, on the other side, has at least 5 dimensions that need to be taken into account. Independence as to the substance of representation, what can be said, what can be brought forth. Second, informational independence, which means effective access to information. Financial independence, availability of own financial resources. Personnel independence, sufficient human resources to fulfill the representative tasks, so not one single person alone can do all this. And temporal independence, by which I mean that the status as a representative is not coupled with political periods of office, so that the next government can just abolish the position. Presumably, the representation of animal interests by humans will always remain somewhat fragmentary. But we can try to fill the gaps that I tried to bring up here as best as we can, and to compensate the, I think, inevitable deficiencies in order to come as close as possible to an equality of arms in legal proceedings for animals. Thank you very much.